So fundamental rights are enshrined in Part 3 of the Constitution. Part 3 of the Constitution deals with the fundamental rights, and the articles are from Article 12 to 35. So in the Part 3 of the Constitution also we have the articles is from 12 to 35. They all deal with the fundamental rights. The fundamental rights has been derived its inspiration from the Constitution of the USA. From the Constitution of the USA is where the Bill of Rights is also being is their fundamental rights. It is justiciable in nature. So we say that the fundamental rights are justiciable, and they are Magna Carta of the India. Magna Carta of the India. So fundamental rights, when you look into the fundamental rights, the first thing is they are justiciable and they are Magna Carta. The fundamental rights are the Magna Carta of India. Guaranteed to all the citizens. The fundamental right is guaranteed to all the citizens without discrimination. These rights are essential for all-rounder development of individuals. Right? The fundamental rights are guaranteed to all the citizens. It is without any discrimination. And these rounds are for the all-rounder development of individuals. Part 3 is also called as a cornerstone of the Constitution, and together with Part 4 it is called as a conscience of the Constitution. So Part 3 and Part 4 together they are called as conscience of the Constitution, whereas Part 3 is called as the cornerstone of the cornerstone. Part 3 is the stone, and together they are called as a conscience. Now features this fundamental rights are nothing but limitations on the state. It provides for a limited government. So here we'll be having that there are limitations for on the state. The limitation is provided on the state, therefore we are able to have a limited government. The limitation is provided on the state. Some of them are available only to the citizens. So some of the fundamental rights are available only to the citizens. Article 30 is cultural and educational rights. 29 and 30 are cultural and educational rights. So the cultural and educational rights, the cultural, and then we have the educational. Cultural and educational rights are available only to the citizens. Article 15 is discrimination and Article 16 is opportunity. The discrimination and opportunity is also available only to the citizens. And Article 19 is freedom, right? Only 5. So the 5 is 15, 16 and then 19, right? 15, 16, discrimination, opportunity, freedom, and 30, 29. 30, 29 are cultural and educational rights of the minorities. The fundamental rights are different from the legal rights. The legal rights are protected and enforced by the ordinary law, but the fundamental rights is protected and enforced by the Constitution. How the fundamental rights are different from the legal rights? We say that these legal rights are protection is provided for even for the legal right, and they are also enforced by ordinary law versus the Constitution in itself. Protection and guarantee by the Constitution. So this is how we say that the fundamental right is different from the legal rights, because the first thing is the protection, right? The protection, and the second thing is going to be the enforcement. The protection, and then we also have the enforcement. Both the protection and the enforcement is provided by ordinary law, just a normal law in case of a legal right, whereas the protection and enforcement, that is the guarantee, is provided by the Constitution itself for the fundamental rights. Now first we say here it is limited government fundamental rights, and what are the articles which are applicable only to the citizens is Article 15, 16. 15 is discrimination, 16 opportunity, 19 freedom, and 2930 cultural and educational rights of the minorities. They are not absolute, they are qualified in the sense that the state can impose reasonable restrictions on them. They are not absolute, they are qualified. So, in the sense, there are restrictions for the fundamental rights. Most of them are against the state, and few are even against the private players, like right against untouchability and child labor, Article 24. These things, there are few fundamental rights which are even against the private players, but most of them are against the state, right? So most of them are against the state, but few are against the private players. The best example is right against untouchability. There some are negative, most of them are actually negative because they are limitations on the state's authority. Why do we say that they are negative? Because they impose limitations on the state authority and protects the individual from the state. It is to protection of the individual from the state interference. The rights demand inaction from the state, right? For example, Article 17 is you don't do any actions, they demand inaction. They want the state not to act. For example, they want the state not to act in favor of untouchability, and they don't want the state to allow titles, right? So we say that they are negative. Negative in the sense, apart from limiting the authority and protecting the individuals from the state interference. So not in non-interference also. Limitations plus you don't interfere as well. Some are positive, they confer certain privileges upon the people. State is obliged to do something for the citizen. Example under Article 19. Right. So let us discuss these three again, revise these three. So most of them are available against the state. Most of the fundamental rights they are available, they that too against the state. But only a few fundamental rights are available against the private players as well. Example is the rights against untouchability. And then negative is limitations to the state's authority plus protect individuals from the state's interference. Limitations plus also protecting from the interference. These rights demand inaction from the state. And the example is Article 17 and 18. Some are positive. It confers the privileges upon the people, and some the state is obliged to do something for the citizens. Example is Article 19. They are justiciable, right? They are justiciable, that is, they are defended and guaranteed by the Supreme Court under Article 32. The court, I mean, they can be curtailed by the parliament by a constitutional amendment. They are subject to curtailment, that is through parliament's constitutional amendment. But this is again subjected to the basic structure of the constitution. Loosely, the fundamental rights are borrowed from the Nehru's report, US Bill of Exchange, English Bill of Rights, and French Declaration of Rights of Man. So, from where these fundamental rights are borrowed? First is Nehru's report, US Bill of Exchange, English Bill of Rights. So, we have to tell that the US, we think that the US Bill of Rights, right? But it is Bill of Exchange, whereas English UK's Bill of Rights. And the French Declaration of the Rights on the of the Man. Right. So these are the places where the fundamental rights has been borrowed. One in India, Nehru report, US is having the Bill of Exchange and English is having the Bill of Rights. French is having a declaration of the rights of man. Can be suspended during national emergency except so they are suspended during a nationwide emergency. Their suspension is only during the national emergency. The national emergency, even though the national emergency, Article 20 is right against detention. And not right against detention, Article 20 is right against the conviction of offences. They are having protection. Even conviction of the offences are having protection, irrespective of any circumstances, whether it may be national emergency. And Article 21 is with respect to life and personal liberty. Right. Now, limited by the limitations of fundamental rights is provided under Article 31A, 31B, and 31C. Now, we have seen these three articles once again. So let us revise these 4 points. They are justiciable. That is, they are guaranteed and defended by the Supreme Court under Article 32. Now, can be curtailed, they can be limited, or they can be deleted whatsoever. They can be limited, deleted by the Parliament. This is through a constitutional amendment, but it is subject to the basic structure of the constitution. Loosely, the fundamental rights from where they are borrowed from. They are borrowed from the Nehru Report, US Bill of Exchange, English Bill of Rights, and French Declaration of the Rights of a Man. Now they are suspended during the national emergency, but even though there was a national emergency under Article 352, what are not getting suspended? Article 20 conviction of offences and Article 21 right of personal life and liberty are not suspended. Limited by articles is 31A, B, and then we have the C. Right. Now, there is a limitation to the fundamental rights. This limitation to the fundamental rights. The fundamental rights are limited by Article 31A, 31B, 31C. Now, Article 31A is related to serving of the laws for providing acquisition of the estates. Land reforms. This is related to land reforms. You are acquiring an estate. You save a law which is for acquiring an estate. And 39B is ninth schedule. Whatever the validation of the acts and regulations included in the ninth schedule. And 39C is saving of the laws, giving effect to certain directive principles. So this is related to DPSP. This is related to estates, acquisition of the estates. And here you have ninth schedule. Right. Now, fundamental rights are having certain limitations. These limitations are provided in Article 31A, 31B, and then we have 31C. Now, what is Article 31A? You are saving certain laws. These laws, which are providing acquisition of the estates, even though they infringe certain fundamental rights, these laws are serving as a limitation to those fundamental rights. So, acquisition of the estate. Save the laws for providing acquisition of the estates in under 31A. What is 31B? Now 31B is ninth schedule. Saving of the laws, the validation of the certain laws and regulations included in the ninth schedule. 31B. Now 31C is saving of the laws giving effect to certain directive principles. Not all directive principles. Usually 39B and 39C are those directive principles. Right? You are saving laws to give effect only to certain directive principles. So the first is acquisition of the estates, ninth schedule, directive principles. Estate ninth schedule, and then we have the directive principles, right? Only the parliament can make law for the enforcement of the fundamental rights, even though they are self-executory. The parliament alone has the authority to make laws for the enforcement, right? Even though most of them are self-executory. The application to the members of the armed forces, paramilitary, police forces, intelligence agencies can be restricted. These are restricted or abrogated by the Parliament under Article 33. So the application is restriction of the application to the first one is army, right? Army, paramilitary, police forces. Intelligence agencies can be restricted or abrogated by Parliament in Article 33. Article 32 is constitutional remedies. Article 31, here we have 31A, 31B, and then we have the 31C, right? Article 31 has been deleted. It was right to property. So for right to property, you are having certain limitations. Now, here 32, we know that it is constitutional remedies. What is 33? We are providing restriction or complete abrogation of fundamental rights for the members of the army, armed forces, then paramilitary, then you go for the police forces, right? Top army, next lower paramilitary, police, and even the intelligence agencies, right? Now, right to property was deleted by the 44th Constitutional Amendment Act of 1978 and it was made a legal right. Right to property is a legal right, and this right is under Article 300A of the Constitution. So, legal right under 300A of the Constitution. Definition: what is Article 12? Now we are going to discuss about each articles. What is Article 12? Article 12 deals with the definition of the state. What does this definition of the state includes? The government is nothing but the executive, and parliament is nothing but the legislatures. Like union executive is the government, and union legislative is the parliament. So the government and the parliament of India, government and the legislatures of the state, right? So union executives and union legislatures, state executives and state legislatures. So first the executive and then we have the legislatures are included over here, right? The government and then the Parliament of India, government and the legislatures of the state. Then we have the local authorities. Local authorities such as the district boards, Panchayat Raj institutions and urban local bodies. All the three-tier government is being included in the definition of the state. So definition of the state is under Article 12. Article 12 deals with the definition of the state, right? Now, under the definition of the state, we are going for the government of the India is included over here, and the Parliament of the India is also included over here. Government and the legislatures of the states. Here, local authorities like the district boards, Panchayat Raj institutions, and urban local bodies, right? And other authorities in the sense they are statutory, that is, they are made by the law, or they are non-statutory as well. They have a parliamentary law or they are not having a parliamentary law. That is what other authorities mean. Now, Article 12. Supreme Court states that even private bodies which are working as an instrument of the state acts uh, it acts as an instrument, a private body which is acting as an instrument of the state also comes under the Article 12. So, and private body working as an instrument of the state. The actions of these agencies can be challenged in the courts for violating the fundamental rights. Right. First is the government and the Parliament of India, government and Parliament of state legislatures. Then we go for local bodies, and the bodies or local authorities, either it could be statutory or non-statutory. Example is LIC, ONGC. Now, even private bodies which are working as an instrument of the state, the actions of these agencies can be challenged in the court for violating the fundamental rights. What is Article 13? Article 13 is like provision for the judicial review. So, judicial review is indirectly mentioned in Article 13 of the Constitution. The word judicial review is not directly mentioned in the Constitution. Article 13 states that if there law any law which is inconsistent or in derogation is opposite to the fundamental rights, it shall be void. Right. Any law which is inconsistent with or in derogation of the fundamental rights. Inconsistent with or it is in derogation of the fundamental rights shall be void. So any law, it can be any law. This law is in derogation or it is inconsistent with the fundamental rights. This law is stated as the void. Supreme Court under Article 32 and High Court are having under Article 226 have the power to judicial review. So the power of judicial review. Here we are mentioning in Article 13 judicial review indirectly that if there is any law and this law is in inconsistent or in derogation of the fundamental rights, this law shall be void. This Supreme Court is having the judicial review under Article 32 and High Courts are having judicial review under Article 226. Law for the purpose of Article 13 is the laws enacted by the legislature, even the ordinances, executive legislation in the sense, sometimes what is called as delegated legislation. Delegated legislation. Parliament delegates some of its power to the executives, or if the parliament is passing a law, it just gives a overall skeleton of the law and the procedures to be followed for executing the laws are decided by the executive. So the executive are having the power to make an order, bylaw, rule, regulation, or even notification. Here we have custom or usage of having a force of the law, right? Everything are included in this. Article 13 does not define a constitutional amendment as a law, but Supreme Court said that constitutional amendment can also be challenged. This is in 23rd Constitutional Amendment Act, where the Parliament has passed 23rd Constitutional Amendment Act and included that constitutional amendments are not law, right? Constitutional amendments do not fall under the category of law. What comes under the category of a law? A law is nothing but laws which are enacted by the legislatures, both the parliament and the state legislatures. It can be an ordinance, or we also have the executive legislation. What does executive issues? The executive issues orders, rules, bylaws, regulations, and even customs or usage which are having force of the law. And Article 13 does not include Constitutional Amendments Act as a law. But a Supreme Court stated that the constitutional amendment can be still challenged if they are violating fundamental rights, because the fundamental rights are part of the basic structure of the constitution. This is said in the Keshwananda Bharati case in 1973. Now, the Constitution of the India is in part 3. We have the fundamental rights, right? Right to equality is having equality before the law, and then we have the equal protection of the law. And we have prohibition of the discrimination on the ground of the race, religion, caste, sex, and place of birth. And equal access, here there is also another part, right? Equal access to the shops. We are giving equal access to the shops, hotels, public places. In discrimination, there is also equal access to public places and equality of opportunity in public employment, abolition of untouchability and abolition of the titles. Article 14, 15, 16, 17, and then we have the 18. Five articles are present under the right to equality heading. The first is Article 14, which states about equality before law and equal protection of the law. Then we have Article 15. This is related to the discrimination. Should not be discriminated on the grounds of race, religion, caste, sex, or place of birth, and also allowing access to public places like equal access to shops, hotels, wells, tanks, bathing guards, roads, etc. Now, equality of opportunity in public employment. This is under Article 16. Article 17 is abolition of titles, and Article 18 deals with, Article 17 is abolition of untouchability, and Article 18 is abolition of the titles. Now, right to freedom is Article 19, 20, 21, 22. 19, 20, 21, 21A, 22. Now, right to freedom. Right to freedom is going to be the protection of the right to freedom of speech and expression. You are speaking, right? When you are speaking in mic, you need few people to listen to it. So, this is assemble peacefully, and you are forming an association. They are forming an association, and they start moving to every part of the territory, like the prime minister is coming to any states and he is addressing the meeting, right? That is what move freely. First is right to freedom of expression, and then they are assembling peacefully. People just assemble. If somebody is speaking, people just assemble to hear what they are speaking, and if they are impressed, they are forming a union. They are forming an association or a union. Here we are also cooperative are included over here, right? Right to form association, union, and cooperatives. So the first is when you are speaking, people must assemble peacefully. When people are assembled, you are forming an association and you are moving freely. So four things are compressed over here. But at the end of the day, you need to settle somewhere. Therefore, reside or settle in any part of the India. We need to reside or we need to settle in any part of the India. Reside, and then we have to settle in any part of the India, practice any profession, or to carry any occupation, trade, or businesses. This is Article 19. Article 20 is right in respect of conviction of offences. When you are convicted for any offences, what is the procedure needed to be followed? So, right in the protection of conviction of the offences. Article 21 deals with the right to life and personal liberty. You are going for life and personal liberty. 21A is right to education, and 22 is right against arrest and detention in certain cases. First they are arresting and then they are detention is holding the person in hostage, right against arrest and detention in certain cases. So first article for freedom we have five articles again, right? So article 19 is protection of the right to freedom of speech and expression, assemble peacefully, association, union, move freely throughout India, reside and in profession. Now in Article 20 we have right protection in respect of conviction of the offences. Article 21 is right to life and personal liberty, and Article 21A is right to education. Article 22 is protection against the arrest and detention. They are arresting first and they are holding that person captive, is what we call it as a detention, arrest and detention in certain cases. Now the next is right against exploitation. You are being exploited, right? So first is you should not kidnap anybody, prohibition of traffic in human beings and forced labor, and you should not force anybody to work for you. You should not kidnap us, prohibition of traffic in human beings and forced labor, prohibition of employment of the children in hazardous jobs. So they are mentioning that not the prohibition of employment in children in jobs, hazardous jobs. So to include the adolescents as well. Prohibition of, so this is 24 and this is 23 and 24. Exploitation is 23 and then we have the 24, right? The first one is prohibition of the traffic in the human beings. You should not kidnap anybody. So prohibition of traffic in human beings and forced labor. Next we have 24. 24 as the prohibition of employment of the children in hazardous jobs. Children are not supposed to be employed in hazardous job, right? Right to freedom of religion. 25, 26, 27, 28, right? The freedom to conscience and free profession, practice and propagation of the religion. You are professing a religion. Yeah, I do profess Hinduism, Christianity, or Muslim, right? You are professing about a religion, then you start practicing the religion and then propagate that religion. So, profession, practice, propagate, right? Freedom of conscience. They say that there is freedom of conscience and free profession, practice, and propagation of the region. The freedom to manage the religious affairs. You are managing your own religious affairs. Freedom to pay taxes for the promotion of any particular religion is 27. The 26 is freedom to manage you are managing your religious affairs, right? What is 26? Right to freedom of religion, right? In under right to freedom of religion, we have Article 25 is freedom of conscience, and first is conscience. So after freedom of conscience, we'll be having the free profession. You are having a profession, then you practice it, and then you have started to propagate it. Freedom to manage the religious affairs. You are managing your own religious affairs. And freedom to pay taxes for the promotion of any particular religion. And freedom to attend religious instructions or worship. Tax, and then we have the religious instruction or worship in certain educational institutions. So, religious instructions or worship in the certain educational institutions. Cultural and educational rights is protection of the language and the culture of minorities. First is language and then culture. Religious and linguistic is mentioned over here. Rights of the minorities to establish educational institutions, right? Protection of the language and culture of the minorities. The first one is going to be the language, and the second one is going to be the culture of the minorities. Educational rights. To establish an educational institution. Right to constitutional remedies. This is 29, 30. 31 is being abolished and 32 is right to move to the courts to issue directions, orders, writs for the enforcement of fundamental rights, right?